achieve unitary status in the following green factors that I just talked about: student assignment, faculty assignment, and quality of education, which refers to discipline and graduation pathways. It ordered further relief and the closure of Catahoula Elementary. The board appealed at that time, and keep in mind that at that time when that was brought about, it didn't happen. The board appealed at that time. 2015 and 2016, the parties entered into consent orders regarding those, again, green factors, which included the remaining factors of student assignment, faculty, and quality of education. There was a finding that the 2015 rezoning that took place, it occurred, but the goals were not met. So in other words, we were ordered to rezone to try to alleviate some of the vestiges that were discussed, but again, those goals were not met. At that time, the parties agreed that the board had achieved unitary status in extracurricular activities. So when the information that was presented in reference to extracurricular activities was brought about, it said the board had achieved unitary status in that area. Between 2018 and 2021, the board moved for unitary status in all of those remaining areas. In 2019, the board achieved unitary status in staff assignment and transportation. So in other words, they say that the system was not operating or assigning staff and assigning kids to bus routes in a segregated manner. In 2021, the board achieved unitary status in facilities, quality of education, but only in relation to academics for in-grade retention rates, graduation rates, and program assignment. The board had still not achieved unitary status as it relates to student assignment, faculty assignment, quality of education, which is discipline, and quality of education with our graduation pathways. If you recall, in 2021, Catahoula Elementary was ordered to be closed. At that time, the parties were ordered to craft a new desegregation order, which involved developing a robust magnet program and to continue the transfer policy that was already in place. If you look at record document 744, it basically spells out exactly what took place. And I use this for reference because I want you to be able to see what the documents that I'm referring to and where the information is coming from. And that portion that was highlighted is key. It said in order that the district close Catahoula Elementary, the court also ordered that the parties work together to craft a new desegregation order that would institute a robust magnet program at St. Margaret Primary and the Early Learning Center and comply with the mandate of the student assignment consent order. So for some contextual background, what is a court order versus what is a consent decree? So, and under a court order, who decides? The judge decides. With a consent decree, the parties agree to what is going to happen. So when we talk about parties agreeing to certain things that are going to happen within the district, is because the parties, which would include the private plaintiffs as well as the district, have agreed to these particular, particular items that they're going to follow. Is it voluntary? No. If it's court ordered, it's not voluntary and it can be imposed. The consent decree is yes, because it's a negotiated settlement. In other words, there's a give and take on each side. So it's not necessarily the court coming in and saying, under a consent decree, you have to do these things. It's a mutual understanding and an agreement that yes, these things are going to be done. Is it legally binding? Both under a court order as well as under a consent decree, they are legally binding. In other words, the board can't just say, or the staff can't just say, oh, we're not going to do this, or we're not going to follow what this court order or this consent decree has outlined. What is the judge's role in all of this? Under a court order, she's the active decision maker. So she makes the decision in reference to a court order. Under a consent decree, her role is to monitor, to review, and to enforce it. So periodically, you'll see that we have status conferences and things of that nature. That's because the judge is monitoring what is taking place, She's reviewing what has taken place, and she ensures that what she's spelled out or what we've agreed upon is being enforced.
And the superintendent, I would just say, it's just a minor addition to that. The judge is also a reviewer and monitoring enforcer under a court order as well.
And our typical use, a court order is typically after finding a violation. So, consent decrees are used to avoid trial and to try to resolve disputes. And lately we've been in a lot of, trying to resolve disputes, to try to come to a happy medium, to try to get this case beyond us. But that does take a lot of work, and to continue, give and take and compromise by both parties. Where are we? So in 2022, the Fifth Circuit of Appeals Court reversed the closing of Catahoula School, but remanded it back to the district court for consideration of other methods that could be used. So remember, the district appealed to the Fifth Circuit. The Fifth Circuit said, yes, with all of these green factors, you didn't meet the requirements that you needed to meet. However, the closure of Catahoula was something that we remanded back to the court, back to district court. Okay. As I mentioned, all of the green factors were upheld and remanded continued oversight in efforts to achieve unitary status. In 2023, the court adopted the plaintiff's proposal for opening of Catahoula Elementary, which was record document 744. The stipulations in the court order for opening of Catahoula Elementary: successful completion of the first year of the magnet academies and signing of the magnet plan. It could only be opened as pre-K to 1 or JSEP, but it should not be used for grades 2 to 12 or any variation thereof. So it could only be pre-K to 1, or we could have moved JSEP there, but it couldn't be used for any variation thereof. It may operate as an after-school program or community events. It reverted back to the original zone for Catahoula. And it was specific in saying that the district shall not recruit staff, faculty, or allocate resources to Catahoula Elementary in a manner that hinders, impedes, or is inconsistent with its compliance with the magnet consent order or any other order entered in this case. And that bullet is very, very significant, because when the Fifth Circuit remanded it back to the district court in 2023, the court order that was issued by the district judge in this case spelled out all of these stipulations that were written here. And the reason I'm saying that is because it's important that you understand that the magnet plan was not signed until 2020, or literally 2025, which was our first year, and I'm going to get to that slide, which tells you that in 2023, when this was all put into place, there was a method to what you're seeing right here. So, where are we? In 2024, we opened the 2 magnet academies. St. Martin Early STEAM Academy and St. Martin STEAM Academy. In 2025, which was 2 years after that district court, the Fifth Circuit remanded it back to the district court, and the district court spelled out exactly what you needed to do in order to have Catahoula reopen. The magnet implementation plan was signed by the court, and the successful completion of year 1 of the magnet academies was achieved. Where are we again? If you pull JCampus data, which was pulled by our IT department, for 2025, Catahoula Elementary, if it were to open with the zones that were spelled out in the 2023 court order, you would have 7 total pre-K students, 8 kindergarten students, and 8 first grade students. You'd have a total of 4 blacks, 19 white students. Key factors affecting the reopening of Catahoula Elementary as with the provisions that are in the court order, which is record document 744. The court order provisions and implications is really a non-compete with the magnet academies. Remember when I went back to the 2023 court order and I discussed what was outlined in the 2023 court order when it was remanded back to the district court after we appealed to the Fifth Circuit. So all of those green factors were upheld or affirmed with the exception of the closure of Catahoula. And when it was remanded back to the district court, the court order that was issued in reference to the reopening of Catahoula had those specific things in it. So in our magnet plan, that school's pupil-teacher ratio has to be 18-1. And in the magnet plan, it specifies no other school can have that 18-1 ratio. It can only be at those two schools. So the ratio at Catahoula, they would need at least 19 kindergarten students and at least 19 first grade students. If the above provision is made, then meetings could occur to develop a plan for reopening Catahoula that must be proposed to the court for approval prior to opening. It can't just be the board saying, oh, we're going to reopen without it actually having to go before the court and the court make a determination as to whether or not it's going to reopen. So, and again, I wanted you to see record document 744 because I didn't want the public to think that I was pulling this from out of the air. It clearly states the district shall not recruit staff, faculty, or allocate resources to Catahoula Elementary in a manner that hinders, impedes, or is inconsistent with its compliance with the magnet consent order, record document 694, or any other entered in this case. Where are we going? To ensure maintenance of the Catahoula facility, the following will occur. To begin with, the district is creating a professional development hub and training center for St. Martin Parish School Board for administrators, teachers, and other essential staff. Other beneficial programs and resources are going to be explored for the use of Catahoula. Why? That's the big question. Why? The goal or the end result is to achieve unitary status. It refers to the federal court's determination that the school district has eliminated the vestiges of past segregation to the extent practicable and is now operating a school system that complies with the Equal Protection Clause of the 14th Amendment. Achieving unitary status means that the district is no longer subject to court oversight or supervision under a desegregation order because it has met its constitutional obligations in the following areas: student assignment, faculty assignment, quality of education, which is discipline, and graduation pathway.
I got some. Mr. Willis,
Yes.
I heard you say that the reason why the board knew that, and the court said that we was not unitary status, but we were warned several times under Mr. Jack Burson, Chester Cedar, and executive session, you know, that we still was under court order. If we violated a rule when we decided to close Robridge Elementary, that was one of the biggest flaws. When we closed Robridge Elementary, we had to hurry and reopen and make career center. That's when we really violated. As long as we wouldn't violate no U.S. Law, we were good. We could have still been out of the state, you know, and continued to operate. And I cautioned the board that night when they decided to make a motion to shut down Robridge Elementary and move it. I said, you know, we got to seek an opinion from the Justice Department. The board ignored me. I'm gonna tell you the truth. The board ignored me. They went right ahead and done what they wanted. And the next thing came, it fell down. It fell on. We knew, the majority of the board knew that we were under some type of deseg order. Because just like, in the past, I asked the superintendent to send a kid to Catahoula, and there was no problem, we sent them. Because it said that 50 kids must go to Catahoula, period, black. And the board was aware, the majority, the new board member wasn't aware. But you can take that Frederick Steady,
What was your first year doing the board?
1975.
On the board?
No,
Okay.
794.
Okay, so were you on the board when they opened up parks? That was the same thing?
Yeah, but we got opinion from the Justice Department.
I mean,
We did get opinion from the Justice Department. If we would have got opinion from the Justice Department, you would have never heard that.
I was just wondering how
And
they opened up the
everything,
school.
you was
Because that
there,
flawed a lot of things.
Steve was there, Ms. Wanda was there. I said, we got to get opinion from the Justice Department. First thing somebody said, we don't need to do it. I said, well, go ahead, do what you want. And that's when it came to. That's the truth. We'd have been still operating, yeah, we got opinion from Justice Department to open the parks. You can't just open a school without getting opinion.
Any other comment? I don't recall.
And also, another flaw we made. When we negotiate with the DOJ and the other parties, if we would have just went to court, bam, 2019, we'd have been out of that completely. We decided to negotiate, went to Shreveport. That was our worst mistake. Because I knew,
Monroe.
Yeah, Monroe, yeah.
That was in
I knew then that negotiation with them, that wasn't gonna happen. You don't negotiate, you go straight to court with DOJ.
I personally don't think it'll make any difference. What do you think, Steve?
Well, according to the judge in Monroe, she said we're bending over backwards for those people. And should have been over within 2 weeks after we met with her. And then here we are,
That's true.
10, 15 years later, we still fighting.
Mhm.
What did they say to us? Remember that? The judge said, what did the judge say? If y'all, what they recommended was that if we close Catahoula, the whole thing would be finished. That's what they told us, wasn't it?
That's what I said, you don't negotiate with them.
We
Go
did.
straight to
What
court.
did we tell them, Steve?
Y'all let them have the Catholic kids to save the other kids in the parish.
No, listen. What did we tell them, Steve? We told them we're going to court.
We'll see you in court.
That's what we told them. And that's when the judge over there said, y'all are meeting all the requirements. There should be no problem when y'all get to the judge. When we got to the judge dropped everything. and-
Everything
Let me clarify that it was two different judges.
Right.
Yeah, it's two different judges.
The judge that was mediating
Immediate.
in Monroe said that we should have no problem.
Right.
When we got here, the judge that we have now said, I can't believe y'all agreed to that. That's what she said. And that's when it started, right then and there. And in 2014, we had our first court event. We went in Lafayette. So I really don't think anything we could have done would have changed the way things were going. All right, any other discussion on that? Nothing else, okay? We have someone who would like to speak, Ms. Celeste Lachlan. Ms. Lachlan, would you like to?
Oh, I was gonna talk, but I was taking notes, but my question with, y'all couldn't have done anything different. Do you think that in 2015, when Jeff, as getting into Attorney General, wanted to take over the case and y'all didn't take his, stay under his brief and all that good stuff, y'all know the whole drill, that could have drastically changed this whole thing. Because at this point, yeah. So anyway, y'all know the drill. I'm not gonna go over all this again, y'all. Like third and one.
Hold on, any other discussion on the matter?
Well, if she knows so much, why shouldn't get that from the judge?
Well, we did, but
Well, Steve, we've been fighting this since 2015.
Exactly.
No, we were fighting this before that.
In 2015, Jeff Landry was in the run for Attorney General and wanted to file an amicus brief. And it's in note, it's documented, and the school board denied him. They turned him down in 2015. And this is where we are today.
Okay, any other discussion on that matter? No. All right, do we need to go into executive session? No.
No, Mr. President.
So if there are no further, if there is no further discussion on the matter, I'll entertain a motion motion by Mr. Click. Second? Second.
Good explanation.
Second by Mr. Martin.
Superintendent.
Meeting adjourned.
Good information.